It is important to understand the distinction between the redress scheme and other options where you would have a lawyer involved and negotiating and advocating on your behalf. The redress scheme doesn't have that option. There's an organisation called No More that will help you to fill out your claim form, but then there's no contact with the department, with the assessor, in terms of putting forward your claim other than what you've got in your claim form. If there is something that the institution contests about your claim, there is the option for the assessor to contact you as the applicant to seek your response. That is entirely in the hands of the assessor as to whether that's necessary. At the end of the day, the assessor's job is to assess whether it is reasonably likely that the abuse occurred and to assess what institution was responsible. And the scheme does set up a fairly low bar for that assessment to be made. And the connection to the institution, it's not about the concepts that we are used to in the law, which are about negligence and so on. If the abuse has occurred because, even if it was on church premises, for example, that's enough of a connection to the institution. So all of those things have been put in place to make it easier for claims to be made. However, there is no transparency as to how the decision is made. And so the difference where you have a lawyer who's able to represent your interests, to push your argument with the institution, and to confer with you and to seek your input where things might be said that you don't agree with. There are really big advantages in having a lawyer on side through that mediation process. Now, some people, and certainly there's a history of institutions and particularly churches resisting claims. It is very much the case that the landscape has shifted. And of course, there are institutions or particular cases where claims are resisted, but it is certainly a lot easier to make claims than it used to be. A lot of institutions have developed processes which we as lawyers are able to make use of, to engage with those institutions, and to set up conferences, settlement conferences, where our clients' claims can be discussed in a reasonably open way, without too much concentration on legal reasons why claims won't succeed. So that's not to say that every claim is just accepted and payment made, but using those processes is certainly a lot easier than it used to be, say, 10 years ago. When it comes to court cases, sometimes those are harder. That's going to depend on the strength of the claim and the information that we have. But certainly that, for us, is another vehicle, another pathway that we can use in appropriate cases and in consultation with our clients as to whether they're interested in going down that path. But we do now have a range of options available, and that's how we would explain it to clients when they see us for the first time, is to take them through those options, to explain the advantages and disadvantages of each of them, and to try to tailor an approach that suits the client.